Okay. Sorry. Here. So thank you guys. Thank you for coming this afternoon, this warm afternoon, probably one of the latest one. I heard that the wind is going to be coming anytime. We have today with us Jorge Cuello. We've been working with him on a personal basis for some time. So about 6 months ago, we were collaborating when he was part of Deloitte. You probably know the company. And about 5 months ago, 5 months ago, he left the company to start also with another lawyer company, which is quite famous here. Is
Martinez Echeverria Law Firm.
Okay. He's very into M&As and some mergers and acquisitions and everything, a lot of operations. But today, I think we're going to be focusing mostly on some tools for you. Basically, is going to be the shareholder agreements, things that you need to be bearing in mind when you have founders and co-founders. And later on, I think it's a good idea to spend some time, quality time, with all of you. So you can be sitting and interacting with them and asking every single question you have in mind. Okay, so time is yours. And thank you for being here.
Thank you, Rafa. First of all, thank you. I would like to thank to Rafa, Charo, and both team for this invitation in this mentoring program as mentee. And this is the first point. I'm a mentee. I'm not here for a class, I'm not lecturer, I'm not teacher, I'm lawyer, law advisor. And we are here for sharing experience and in order to swap the experience that you have as entrepreneur and as a business developer. And first of all, sorry for my English, maybe no. I'm sure that is not my best skill, but we are trying to improve this skill. Well, before to discuss about the title of this season, shareholder agreement, I would like to begin with 2 tips. First tip is that all kind of agreements or as shareholder agreements should be a bespoke suite. Please be aware with the models because maybe if you use a model, maybe the model is useless for the reason or for the motivation of this kind of agreements. Second tips, all the kind of agreement shall be drafted thinking in that this agreement, it will be breached, okay? At the beginning of all the venture, at the beginning of all the joint ventures, you are in a honeymoon and all is well, all is perfect, but when you are develop a business, the contingencies, the problems with your partners, the problem with your providers, of course, the problems with your clients will be grow up. This is clear, okay? We are going to discuss about the shareholder agreement. Please do not hesitate to stop the speech and for further information in order to clarify one point that is not clear or for sharing or your experience, okay? Okay. Shareholder agreements. What is a shareholder agreements? Is a contract links between the partners and the company with terms and conditions that are not settled in the bylaws or in the company acts, okay? Is a specific vehicle in order to set out some clauses, some terms, some conditions that are not settled in the main law of the company, which is the bylaws or the article of association, and mainly the company acts of the company where the company is incorporated. Who of yours has got a company through you develop your business? You? Jointly? Okay. Spanish company or Malta? Okay. Who has a Spanish company? You. I suppose that's Sociedad Limitada, liability person. Okay. The first lesson is in accordance with the Spanish law. Our main consideration or advertisement is is that the business develop the better way in order to avoid the personal liability, the personal wealth, the personal patrimony, is acting in the market through company in order to avoid the personal liability. Okay, I suppose that in Malta, I don't know the Malta's corporate law, but I suppose that by tax reason, labor reason, the best option to develop any kind of business is under the umbrella of a company, because you've got a firewall that avoid that you can lose, for instance, your house. Okay. Other very important point is the matrimonial regime. If you are married, in order to avoid that the family house or the family wealth is subject to the liabilities of the business, is to arrange an agreement in order to separate the properties of the marriage. Okay. Well, shareholder agreements is a specific vehicle that allow to the shareholders setting out some issues. For instance, business plan of the company is not settled in the bylaws or in the company acts. Well, the shareholder agreements is the perfect vehicle in order to fix how will be developed the business plan and other relations between the partners and the company when you start a business. What is the difference between social agreements and shareholder agreements? Well, social agreements are included in the articles of association or in the bylaws. The social agreements has got efficiency in front of the own company. The shareholder agreements only have got efficiency between the parts. It's something that is not possible to oppose in front of the company. For instance, if you decide that the appointment of one of the directors of the company shall be appointed by one of the shareholders, the shareholder agreements allows this clause, but the bylaws doesn't allow this kind of clause or condition. Why? Because the law, or at least the Spanish law, is set out that is a decision or a competence of the general meeting. It's not possible to set out in the bylaws that one shareholder has got or are entitled to appoint one of the directors or one of the sole director or several directors. Okay. Okay, a shareholder agreement will not be in any case an agreement which is not accepted by all the partners. Okay, the first key of shareholder agreement is something or an agreement that must be accepted and signed by all the partners, okay? If only 2 partners of 5 are the signers, it's other thing. It's an agreement between shareholders, but it's not a shareholder agreement, okay? And the main advantages of the shareholder agreements is that it kind of agreement allows to avoid the company law rigidity, okay? Sometimes the company law is very restricted and you can dispose or you can choose other alternatives, okay? By this reason, the shareholder agreements allows to avoid this rigidity or this very restrictive regime. And all the bylaws, all the matters that are in your public deed incorporation are registered in a commercial register, okay? And all the matter that is in this public deed or in the bylaws is object of publicity. For instance, in your company, the bylaws of your company are in the commercial register. If you visit the web of commercial register, how is the name of your company?
The name,
Denominación social.
Flying Beast Travel.
¿Puedes repetir?
Flying Beast Travel.
Okay. If you visit a commercial register and in the gap of the company name, insert this name, you've got the possibility to see all the bylaws of this company. With shareholder agreement, you haven't got this possibility and is confidential between the shareholder. For instance, a business plan is a very important document that you can't set in a bylaws, and of course you can register this business plan in front of you can record it in the commercial register. In this case, you've got other possibility that is the shareholder agreement that guarantees their confidentiality, okay? I don't know, maybe the earning of the general manager could be set out in the shareholder agreement because you want to maintain it as confidential. You don't like that the earning of your general manager is set out in the documents that could see by anyone, okay? This disadvantage, shareholder agreement has got one important disadvantage. For example, if any shareholder breach the shareholder agreement, the only consequence is that the shareholder who non-fulfillment the shareholder agreement must be damaged or must be pay an indemnification for this damage or for this unfulfillment, okay? If you breach the bylaws of the company, the consequence is, for instance, if you transfer your shares to third, which non-compliance of preemption rights of the other shareholder, this transfer is not valid in front of the company because you doesn't fulfill the bylaws, okay? If you don't fulfill a shareholder agreement, the transfer is valid between the parties, but the shareholder who has not fulfilled the shareholder agreement shall be give an indemnification, but this breaching of the shareholder agreement. Nevertheless, this is a very important point. Is very useful to set out a penalty clause in order to avoid this breaching. Okay, if you set out in the shareholder agreement, the shareholder who doesn't fulfill the shareholder agreement must pay, I don't know, 2,000 or 2 million euro, okay, in a big shareholder agreement, and this is the way to get the fulfillment of all the clauses of the shareholder agreement. We are going to see some clause, some example that we are drafting in some shareholder agreement, okay?
So after the company is established, even with that, companies still having shareholders agreements, one of them, several of them, with any purpose?
Good questions. Okay, when is the moment of the drafting of shareholder agreement? Once incorporate, after incorporate, or before? My advice is that this kind of agreement should be drafted and signed before. But these kind of agreements are alive documents. In fact, we are going to see that one of the typical clauses settled in model of structure of shareholder agreement is the updating or the innovation of this kind of agreement. Okay.
Yes. But once the company is incorporated,
yes,
should it's still just one shareholder agreement for all companies, or for this issue we have one shareholder
no, one for all.
Okay.
One for all, yes. In fact, there are a lot of clauses and with a lot of sections with different areas as relationship with other partners, relation with the company, for instance, dividend distribution. For instance, minimum period of stance in the company is one for all. No, each shareholder agreement. No. It's integral and is very with a plurality of matter and issue. We are going to see a basic structure, okay? But it is the other point that you are. Sharing the moment is or once established or once incorporated. The most part of shareholder agreement that I'm draft has got a specific clause that sets out that each 5 years the content of the shareholder agreement shall be updated because the needs of the shareholder and the scenario and the environment is changing each day, okay? Okay. Shareholder agreements hasn't got a specific law that allow to know the regime, but there are a lot of articles and there are a lot of acts under Spanish law that allows and establish the regime of this kind of documents. This is the basic content of partners or shareholder agreement. There are organization agreements that cover all the structure of, for instance, government bodies as general meeting, board of directors, attribution agreements, for instance, dividends distribution, and relationship agreements between the partners and between the partners and the company. For instance, what happens if one of the partners or the shareholder wants to recover the investment? Okay, this is one of the points that should be regulated in this kind of agreement. All in one document, okay? No, each document for each area. We are going to see a lot of examples of clauses regarding these areas, okay? Okay. At the beginning of this kind of agreements, there are some key areas with the backgrounds of the company, of the partners, and the first clauses usually are regarding the principles of the company government. There are a lot of principles as good faith, equity, professionalism, unity, okay, that is very important because these kind of principles help to interpret the agreements, okay? The interpretation of the agreements, when one partner said one thing and the other one say the opposite, the principles help to set out a solution, to set a solution to this litigation or to this difference, okay? One of the areas was organization agreements. This kind of this area is regarding distribution of the powers between the general board of shareholders, general meeting, who are the owners of the company, and the administration body, who are the representative company and who are the chief executive officer and the top of management of the company. It's very important the relation between them. Okay. In any case, the general meeting is the body where the appointment of the administrators takes place. I suppose that in Malta is the same regime. Who is your administrator? Sorry? Who is the CEO? Is a sole administrator, several, joint? Okay. Okay. And who appoints this CEO? The general meeting, you as a shareholder, or?
I think general meeting is not necessary.
The directors.
The agreements of the founders is
founders as shareholders, as stakeholders, appoint the CEO. Okay, here. Okay, imagine that you've got a board of directors. You incorporate a company with 5 partners, and you decide that 3 of them will be the directors. You've got a general meeting with 5 partners, a board of directors with 3 directors, and imagine that you need to sign a loan or to sign a very important agreement with a very important client. The 3 directors go to sign a important agreement, because it's not operative. You need that one of these directors has got all the powers in order to make easy the operation and the day of the company. In this case, our advice is that the board of directors appoints one CEO, okay, and he has got all the powers of the company. The problem is the trust in this person, because must be a person full of trust, and obviously is something. I'm a little bit concerned when someone appoint some persons, okay, because CEO has got all the powers of the company. Regarding organization agreements and general meeting, there are a lot of matters that you can agree. For instance, both syndicates is other important issue. Some of the stakeholders or some of the partners could be agree a syndicate of shareholders and decide between them the sense of the vote, for instance, in a general meeting. But this area could be set out in a general in a shareholder agreement. This is unization of vote is the syndicate of votes. This is very usual in stock change companies that, for instance, IBEX 35 or NASDAQ. And the other government body is the board of directors or the governing body. In accordance Spanish law, you can choose between sole administrator, who has got all the power as CEO, several administrators, or joint administrator, okay? The other possibility is a board of directors. Well, in the shareholder agreement, you can agree the number of directors who the partner is entitled to appoint, okay? For instance, if you've got the 70% of the equity, you are entitled to appoint the most part of the directors. It's very easy to understand, aren't you? If you've got 5%, maybe you are not entitled to appoint one director, and you are only in the equity. You are not in the government body. Regularity of meeting. This is very important. Here in Spain, the shareholder meeting or the general meeting and some board of directors, the meeting is only once a year. This is very dangerous because you need the meetings of the government body in order to check the development of the business. In fact, there is an update of the Company Act that set out the obligation of the board of directors to meet at least once at each 3 months, okay? This is a very important point because when you appoint a CEO, you've got the problem that if you can, or if you want to dismiss her or it, sorry, if, for instance, you appoint a CEO and in 1 year you see that is not valid for the position of general manager or chief executive officer. If the general meeting of the board of directors decides the resignation or the dismissal of this person, the CEO hasn't got the right to earn something. The most part of good CEOs has got one right called golden parachute that consists in an indemnization when the board of directors or when the general meeting decides to dismissal the CEO. The most part of the companies, the CEO is the shareholder of the company. In this case, he or she wants to set this kind of clause. Okay, this in fact this is a clause of one of our shareholder agreements, a very important company of health area with a lot of hospital. The CEO wants to set this clause. Okay, you see it? Are you agree? No. There are a lot of jurisprudence that allows the golden parachute clause. Okay, there is a lot of arguments about the validity of this kind of clause because the general meeting must be completely free to decide the appointment of our directors and, of course, the resignation or the dismissal of this person. But there are a lot of jurisprudence of the Supreme Court, for instance, in Spain and in Europe, that allows the golden parachute.
No matter what the reason is of termination?
No reason. Ad nutum, we say in Latin. Is a trust position. You are free to appoint and you must be free to dismissal. But maybe a golden parachute, you are not completely free because if you decide the resignation, you must pay a lot of money. And this is the reason of the argument about the validity of this kind of the clause. Okay. The relation of the here in Spain, we've got a lot of arguments with. I'm a corporate lawyer, okay? I'm not labor lawyer, I'm not tax lawyer, and we've got a lot of arguments with my colleagues from labor area because the relation of the CEO or the general manager are not a labor relation, it's a corporate relation. There are a lot of jurisprudence that said that in corporate relation merger the labor relation, and you can say, "Hi, you are the CEO, and whenever I want, you are not the CEO." Yes.
Is it also applicable to CFO, CTO?
No, it's not the same. The most part of CFO are a special labor relation. Top of the there are a lot of laws that regulates or that set out the terms and conditions of this kind of relation. We say high direction, high management. Okay, has got a special regime regarding the indemnization, regarding the holiday days. It has got a specific regime, okay? Other very important point that could be set in a shareholder agreement is the limitation of the CEO. You can set a lot of kind of limitation. For instance, the investment in asset higher than, I don't know, 1 million euro. In this case, the CEO is not allowed, is not empowered to close an agreement with this scope. You need the consent of all the board of directors, even though of the general meeting. This is a new point. This is an update of the Company Act, and it's a directive of European Union in order to clarify the management of the body, and in order to allow to the owners of the company, who is the shareholder, to make a veto right to this kind of operations. For instance, for the agreement with provision services about, I don't know, ITs, you need the other directors, even though the general meeting of the rest of shareholders. This is very important point, which is set in all the shareholder agreement that I drafted. Here we've got some examples regarding the appointment of CEO. Okay, you've got the model of shareholder agreement in Spanish. Ah, okay. We are going to translate. I've got the translation here, but knowing all document, okay, a whole document.
You can tell me the price on the.
Okay. For instance, here is an example of clause. For instance, you can appoint two jointly responsible CEO. It's not only one. You can appoint two, but it's not operative, because imagine that you need to sign a important agreement in France and you are here in Malaga. It's very expensive to the payment of a travel for two, and the most part of the cases is only one CEO. Okay. Other very important areas is the setting of reinforces majorities. Okay. For the agreements in general meeting of for instance, 80% for the modification of articles of association. This is a very important area, because you can set out a high participation or high percentage of the equity for to get or arrange a decision about the main aspects of the company. Okay. Other very important area is the information. Okay, we can establish in the shareholder agreement the periodicity of the information. You can set out that each month or monthly, all the shareholder has in their emails or in the with postcard executive report with balance sheet, with treasury budget, with a breakdown of the debt, or maybe half yearly, all the board members, board of directors minutes or employments generated. This is some examples that we draft in some shareholder agreements. Well, regarding attribution agreements, very funny clause is the dividends distribution. Here, each shareholder has got their needs. Maybe one shareholder needs cash for investment, and other shareholder is not interested in the dividends distribution. Well, the shareholder agreement is a perfect vehicle to set how is the dividend distribution policy. Here we've got an example of clause that sets out that the parties agree not to share dividends until the positive results of the company allow to attend the provision of financial needs. Please be aware with this kind of provisions, because the most part of the countries has got a specific law that allows to the person or the shareholder who hasn't got dividends are entitled to leave the company, of course, with the payment of the price of the shares. Okay, it's very we've got a lot of, we are concerning when we draft or we write this kind of provision, because some shareholder could exercise their right to leave the company, because the reason of the company is the dividend and the profit, but the financial needs of the company maybe requires that the dividends don't go to the shareholder, that the financial needs requires that the resources of the company stand in the company as reserve or as net equity. Okay. Non-competition agreement. This is very important clause. We've got we draft a lot of shareholder agreements with a lot of companies that are competitors in the same market area. Okay, it's very important to set in the shareholder agreement that the partner not carry out competition with the company. Okay, this is an example of non-competition agreement. Okay, the parties are committed and obligated to not carry out competition to the companies working as freelance or as the employee of other company. Okay, is a very important, it's a key matter that you must take into account.
Shouldn't that part having a time after some partner goes out? For example,
yes,
you have to stay 5 years, 10 years.
Under Spanish law, 2 years is perfect. More than 2 years, the efficacy and the validity of this kind of clause could be a problem. 2 years, perfect. After 2 years, maybe it's not valid.
For example, on the Spanish law, shareholders agree that disputes would be not like in the Spanish court, but in Britain common law, for example. Is it possible for all the disputes between the shareholders must be done in Spanish?
Well, at the end of the shareholder agreements, there are general clause that which container is the applicable law and jurisdiction. Okay. In fact, I've got general provisions is the end of the shareholder agreement and includes one clause regarding the applicable law, and very important point is the jurisdiction where you could litigate about the breaching, for instance, of the shareholder agreement. Okay, I've got here.
Because it mentioned that, for example, we can't stay over 2 years and Spanish and so on. There might be other mistakes. Is there a possibility to have like disputes happen and the Spanish or another form the agreement and the Spanish?
It's possible. We've got a European reglamento that established, that said that the laws regarding the companies is of the country where the company is incorporated. Okay. For instance, the call of a general meeting of a Spanish company is under a Spanish Company Act. But the agreements between the shareholders or stakeholders could be under Malta law, UK law, or Spanish law. You can choose that some areas of the shareholder agreement is under UK law, and other one, for instance, non-competition agreement, is for under Germany law. I'm going to check. Here it is. Applicable law and jurisdiction. Okay, the least proof concerning the courts where the difference between the shareholders of the company are going to be resolved in the case of any conflict, as well as the law which rules the same. Okay, typical clause is any kind of difference between shareholders could be resolved under Spanish law in courts of the city of Malaga. Is typical clause. Okay. This clause acquired its higher importance when the shareholders are from different geographic areas. Okay, this is very important point. For instance, intellectual property is different in USA than Uruguay or than Spain. It's very important to take into consideration this issue. Okay. Well, we are in non-competition. Well, other agreements is the permanence and stability agreement. Okay. For instance, this is other example. The founder shareholder commits to fulfill a minimum permanence deadline of 5 years. And what happens if you are shareholder after the incorporation? Well, the deadline of 5 years is from the acquisition of your shares. For instance, with increased capital, okay, or capital increase. This is very important because, for instance, venture capital are very interested in this kind. Drag along, and minimum permanence is 3 kind of clause that requires by all the venture capital. We are going to see right now tag along and drag along. Do you hear something about this? And could you share with us your experience?
Yeah, I was in the
NISA, okay.
I don't remember which one this was.
Okay, we are going to check some examples.
Yeah, it's about who have to sell first.
Okay. We are going to check, and after we share your experience, okay? Before to discuss about, there are other possibility about the exclusion of some shareholders, for instance, who infringe the prohibition of competency. Okay, the shareholder who is the competitor is out of the company. Okay, for instance, with €1 of indemnization. There are several ways to resolve the problems or the contingencies in the shareholder agreement. We set some examples of serious unfulfillment or non-serious fulfillment. The normal way to resolve is to establish a 1 month period in order to resolve the problems. And if the controversy is not resolved, we can require the judicially fulfillment on claiming the damage, or even though the exclusion of the shareholder who has not fulfilled the agreement. Tag along y drag along. Well, what happened when some of your partner or a group of shareholder wants to leave the company? Well, the rest of shareholder could be in a position that allows him to tag to the shareholder who wants transfer their shares. In this case, we've got the tag along rights. It confers to a minority shareholder the possibility of selling with the majority shareholder his own shares. For instance, we've got a clause with a tag along right clause. In the case that a shareholder wishes to transfer all or part of their share to a third party, the shareholder will have right equally to transfer to the said third party a number of shares which represent is to tag the transfer of shares. Do you understand? The opposite, and is a venture capital requires in all the case, is the drag along. It's the opposite of tag along. In this case, it's not a right to tag, it's a right to drag. In the case that a shareholder wishes to transfer, the shareholder with right to use the drag along to obligate to the other shareholder to sell all the equity of the company for a third person. Do you understand? Could you explain us the experience with ENISA? I suppose that ENISA obligates to you to set a drag along. And
it was not ENISA like an institution. It was an event in ENISA that we went.
Okay. Yeah, the venture capital. Why venture capital likes this kind of clause? Because when venture capital decides to invest its resource, wants to join with the experience of the partners who are in the equity when the venture capital company decides to make the investment. If the partners are different, maybe the venture capital said, hey, if you say goodbye, I want to say goodbye too, with you, to TAG. And in the other way, when a venture capital invests their resource in a company, and after 5 years, for instance, I don't know, WhatsApp, after 5 years, the venture capital find a big investor as, I don't know, Google or Facebook, and say, I found an investor and I want to buy him all the equity, all the company. If the venture capital has the 50%, the venture capital wants to have the right to drag the rest of the shareholders in order to obtain a big price by all the equity. All the equity is more expensive than some part of the equity, okay? And there are a lot of clauses regarding blockage situation and how to resolve this kind of contingencies. The liquidity agreements and disbursement, the investment, and to end this lesson, and pues vamos a pasar al one-to-one.
Sorry.
Sí.
Can you explain us a little bit about the anti-dilution clause?
Sorry?
Anti-dilution clause?
Anti?
Anti-dilution. We have heard about this.
Dissolution.
Dissolution.
Vale, yes.
Not solution, dilution. Right.
Yes. Well, in all, when you incorporate a company, you've got an equity of 3,000 under Spanish law. If you decide the capital increase and you haven't got resources, if the other shareholder has resource, the other shareholder are entitled to acquire all the capital increase. And for instance, if the capital increase is 3,000 more, the new equity is 405,000 for the other shareholder, and you are with 1.5 thousand euros. Well, there are a lot of possibility in order to avoid this situation. How? When we are speaking about the majorities, we set out a majority of 80%. Do you remember? If you don't, you're going to see here.
For example, 18% on 7 from 9.
More than the half, because here. Why we use this kind of clause? In order to avoid the dissolution, because if you need the 80% to modification of the articles of association, the capital increase is a modification of articles of association. One of the articles is the equity. If you need the 80%, you never agree the capital increase, because the other one needs more than their shares. They need, or he needs, or she needs, the consent of the other shareholder, at least at the minimum of 80%. In your case, 50-50. The other one, in order to agree the capital increase, needs the other one, because with 50% it's impossible to arrange an agreement regarding the capital increase.
Yeah, but I think that that's not exactly what I'm looking for. I mean, any investor comes to us and say, I want a 10% of your company for any amount of money. And the company increases because of sales, everything. But after that, when another investor comes out, we share another 10%, but this 10% that was sold to the first investor remains still, because they put an anti-dilution rule.
Clause. Yes.
So that's what we want to know exactly what it means, how to avoid it, etc.
Okay, how to avoid it? In order to avoid it, you can set a preemption right that allows you as shareholder to get these shares. In any case, if you haven't got the resources to pay, to apply this preemption rights, the own company has got the right to buy this transfer. Is something called autocartera. It's the own company, the legal person who has, or which has these shares, and there is a special regime for this kind of share. You can set out in the shareholder agreement that in the case that one of the shareholder hasn't got the resources to avoid this transfer, the own company buy these shares and is forbidding the acquisition of this share by third person or other venture capital or other ways. It's very important because it's not the same to have the half of the equity than the 10%. For finish, and before the one-to-one considerations, there are a lot of areas that must be taken into account. For instance, data protection, intellectual and industrial property rights. It's very important that you set out in the shareholder agreement the terms and conditions of these issues. Okay, who is the owner of the right, intellectual property right of an invention of the company, software, patents, trademarks. If one of the shareholder is the owner of the trademark, what happens with the license is other areas that should be taken into account. Okay? That's all.
So, thank you.
Thank you.
Donde...
Now let's start from the one-to-one. ¿Vale? Sí, no, bien, ¿no?